Hello, my name is Kent DeJean. I'm an attorney and law partner with LeSavio and DeJean. And today we're going to talk about a question many people ask me about that are involved in successions, and that is, do I have to appoint an executor or administrator in a succession? In many states, a succession representative, executor or administrator, is required in all cases. In Louisiana, it is not required that you appoint an administrator or executor in all matters. In fact, in most of my cases, about 80% of them, we don't need to appoint an administrator. We simply are allowed to place the heirs or legatees directly into possession of the property without having the estate administered by an executor or administrator. However, there are some situations in which you have to do it. And some of the examples of situations in which you would have to appoint an executor administrator would be, first of all, if we didn't know what the assets of the estate were. Let's say banks were not talking to the heirs or legatees, and they need to investigate and find out what type of assets are actually out there. Another reason why you would do it would be if there's a lot of debts in the estate that need to be litigated or negotiated out. And so it's necessary to figure out whether or not this estate is solvent and whether or not the heirs or legatees really want to acquire this estate at all. Lastly, one of the reasons why we would do it would be we may need to divide the property up in order to satisfy the bequest. There may be a number of bequests to different heirs or legatees, and because of that, in order to allow that division to take place, we may need to partition it, or we may need to sell the property. So there are some situations in which we would be needing to do an administration. However, in most cases, that's not the case. If you have any questions about administration of successions in general, or any other matters, please feel free to give us a call at 225-769-4200. Thank you.